All right, well, I have 12 o'clock, so good afternoon and welcome to Understanding the Basics of Livestock Market Regulation. My name is Audrey Thompson, and I'm a staff attorney here with the Center for Agricultural and Shale Law. Here at the center, we have numerous resources for agricultural and shale legal stakeholders in rural communities through our website at aglaw.psu.edu. Here on our homepage, we feature our upcoming events, our social media feeds, and our latest Agricultural Law Weekly Review, which provides recent ag law developments, including a full listing of ag-related state and national legislation and executive branch publications. We also publish our Shale Law Weekly Review, which covers recent oil and gas and energy-related developments. All of our publications are available for email subscriptions, so you can receive those right in your inbox every week if you sign up for them. We also host a research by topic feature where we maintain our virtual resource rooms, which provide compiled resources on multiple singular topics in either agricultural or shale law. We also provide our agricultural and shale law issue trackers, which are similar to the resource rooms in that they are focused on a particular topic, but these provide more of a timeline of developments for each issue, so you can see an issue developing through statutes, regulations, or case law. We also produce audio and video content with our Agricultural and Shale Law podcasts, which are available on all of the major podcast platforms, and our YouTube channel, where a recording of this webinar will be posted for future viewing. Additionally, the center operates the Pennsylvania Agricultural Mediation Program, which is funded through USDA. This program has historically facilitated mediations between ag producers and the USDA, but its authorization has been expanded over the last several years, and we are now able to mediate a broader range of issues between different parties. Jackie Schweikler is our program coordinator, so please feel free to contact Jackie with any questions about ag mediation. And finally, on our website, you can find our events tab, which lists all of our upcoming events and presentations and probably where you registered for this webinar. But we wanted to let you know that if you hover over this events tab and click on past events, you can find the PowerPoints and other materials from our previous presentations posted on each event page after each event. All right, so today's webinar on livestock market regulation is part of the Center's Understanding Agricultural Law series, a course of webinars designed to provide subject matter literacy and competence on fundamental issues of agricultural law to attorneys and business advisors who work with or represent agricultural or rural clients, but who may not necessarily specialize in agricultural law. This series is wholly sponsored by the Pennsylvania Department of Agriculture's Ag Business Development Center, which was established through the 2019 Farm Bill. The Ag Business Development Center aims to enhance the long-term vitality of Pennsylvania farms by supporting farm transitions, both from generation to generation and from conventional to organic farming, supporting beginning farmers, providing risk management education, and providing financial assistance through low-interest loans and grants. This is the 6th webinar in the Understanding Agricultural Law series. Previous topics include ag labor laws, farmland leasing for energy development, land use regulation for agriculture, legal protections for ag operations, and agricultural cooperatives. If you missed any of these, all 4 or 5 of these webinars are available on our YouTube site. We do have more upcoming webinars in this Understanding the Basics of Ag Law series, so mark your calendars for Friday, October 21st for crop insurance, and check back to our events page for more topics coming November and December. The center also has several other upcoming webinars that are part of different topical series, which are more advanced in subject nature, including our quarterly dairy legal update series and our legal planning for specialty crop producer series. More information and registration for all of these events is available in our website under events. All right. Before I turn this presentation over to Ross Pifer to explain, or I will now turn this presentation over to Ross Pifer to explain the basics of livestock market regulation. Ross serves as our director for the Center for Agricultural and Shale Law and as director for Penn State Law's Rural Economic Development Clinic and as a clinical professor of law at Penn State, where he teaches property law and oil and gas law. Ross, the screen is now yours.
Okay, thank you, Audrey. Okay, so today we're going to talk about livestock market regulation, primarily Packers and Stockyards. And the Packers and Stockyards is the federal statute that really regulates the business of livestock, or the business practices involved with livestock and poultry. So I'm going to start today's program by giving a real kind of a big picture overview of the Packers and Stockyards Act, kind of the major operation of it. I mean, just within today's program, and we don't have the time to really drill down into all the issues, but we want to provide you with a broad overview. And then Brook is going to then talk about some of the more recent issues involving the Packers and Stockyards Act, and some of the ongoing issues related to livestock market regulation. So, when you talk about the Packers and Stockyards Act or livestock market regulation, I think it is helpful to have a basic understanding of the kind of the biology and the economics of how the livestock and poultry are raised, and who is raising them, to understand when title is passing, what are the business relationships between the companies and the producers. And so, just want to take a minute to kind of walk through the production cycle for cattle, for hogs, and for poultry. So, with cattle, you have a 2-year production cycle, and I think most of us have an understanding of that. But when you think about that life cycle, I mean, that's how much time it takes for the market to respond, or for the producers to respond to any market signals that are being given. So if beef consumption if consumers are increasing their consumption or decreasing their consumption of beef, it's going to take 2 years for the market to really fully respond to that, because that's how long it takes for to get the to increase the amount of cattle that are in the system. And the production cycle begins on so-called cow-calf operations, which are largely small farms scattered throughout the country, throughout Pennsylvania, largely in areas where maybe the cropland isn't as good, or the land isn't needed for crop production. And so, these are generally small operations, often kind of secondary or supporting some other type of agricultural operation, or maybe off farm employment. So you have these cow-calf operations. Cows are born, the calves stay with their mother until they're weaned, and then you have the issue of the calf being fed, or the calves being fed, and at some point move to a feedlot. And generally at say 14 months or so, they're moved to feedlots, which are concentrated in Nebraska, Kansas, Texas, and at that point, then they're fed intensively. And then the so-called packers, the processing plants, acquire the cattle. They're purchasing them at the feedlot. So the title is taking place generally at that point, where the processor is acquiring title from the feedlot. With hogs, shorter production cycle, 6 months. You have a number of different stages. Now with hogs, some operations will really go all the way through. Some are more specialized, and so the hogs may be transferred at different stages, where you have the breeding, gestation, and farrowing, then the nursery and the feeder pigs. Again, this may be combined, it may be separated into different locations. Now there's a much greater use of contracting here, as opposed to in the beef industry. So when the plant, when the processing plant is when that hog is going to the processing plant, that the title may not be passing at that point as it is with beef. Poultry, again, a shorter life cycle, 6 weeks from birth to market. You have generally again, largely governed by the production contract arrangement. So you have the eggs are hatched, the chicks are provided to a contract grower. The grower raises those chicks, does not own those chicks or the broilers. And then when they have finished their growth, and the processing plant will pick up the broilers, which they have always owned. The grower gets paid for the services in raising those broilers. Okay, so I mentioned some about where does title pass and what's the business relationship between the so-called farmer, the person that's raising the livestock or poultry, with the processor. And when you think about kind of that process, or those decisions that are taking place in terms of the production and the transfer of the livestock or poultry, there really are largely four ways that this can take place. And you can view this on a continuum, where at one side of the continuum you have the spot market. And the spot market would be kind of a traditional auction, or where there is a transaction, an individual transaction between the processor and the farmer. The farmer makes all the decisions. The farmer has complete control over production. And then at the end of that process, the processor takes legal title from the farmer. Now, a marketing agreement, there is some type of a contractual relationship between the farmer and the processor, but that's a fairly limited arrangement. And that, as is typical in the beef industry, that marketing agreement is executed really towards the very end of that process, and provides a way to transfer the livestock, to provide a payment, or how the payment's going to be calculated to the farmer. But it's somewhat limited, in contrast with the third bullet point, a production contract, where generally the processor has title to the livestock or poultry, and the production contract is going to spell out all of the terms that the farmer has to comply with in raising that. It's raised in a facility that is owned by the farmer, but the birds are owned by the processing plant. And then you move down to the fourth bullet point, complete integration, where the processing plant would essentially be the farmer. They would own the facilities. The livestock and poultry would be tended to by employees. So in each of these different arrangements, you have more you move towards having more or less control. On one side, the farmer has complete control. On the other side, the company has complete control over how production is going to take place. Okay, the Packers and Stockyards Act. This is the primary federal law. It regulates business practices. It's an old statute, enacted in 1921. It has been amended frequently, and I think last month in this series we talked about cooperatives, and talked about the Capper-Volstead Act, and how it's been pretty static. I mean, it's a short statute, been consistent over the last 100 years. Packers and Stockyards Act has not. It has been frequently amended as the industry has changed, and as industry practices have changed. The Packers and Stockyards Act has been amended to reflect those changes. And just one basic example is just the idea of production contracting. I mean, that was not something that took place in 1921. Now it's very predominant, particularly in poultry and hogs, and the Packers and Stockyards Act now reflects that. So if we go back to roll the clock back 100 years or 100 plus years, and look at what the marketplace was like for livestock at that time, there largely were spot market sales. So the livestock was sold kind of individually. The producers raised the livestock, would take those livestock or transfer them into a stockyard. the Packers would purchase those, or the ultimate purchaser would buy those at the auction, or if the transaction didn't take place through the auction, it was an individually priced transaction. There was no contract prior to that transaction. Now, there were the so-called Big Five at that time. The Big Five Packers had a tremendous amount of control over the markets, the whole market infrastructure, and that included the ownership of the railways, ownership of stockyards, ownership of newspapers. And so they had a incredible amount of control over this process. And there were concerns that there was anti-competitive behavior, that they were engaging in anti-competitive behavior that was harming the producers of the livestock and ultimately consumers. And some of the specific ways in which they were engaging in anti-competitive behavior, I'll just kind of work through some of these specific anti-competitive behavior. So suppression of competition. So if you have one packer would buy a train car of cattle and then sell half of that train car to a competitor. So obviously that's going to depress prices if you only have one bidder on that train car instead of two bidders. Also, again, these so-called Big Five, they own the stockyards, and so when the cattle would be in the stockyard, they still had to be fed, and so they were fed hay, provided other supplies, and the stockyards were charging an excessive amount for the hay and supplies, and the producers really had no way of challenging that. Also, the stockyards had contracts with businesses such as rendering plants, that would provide maybe favorable treatment, and again wasn't really looking at the interests of the producers. The last bullet point on the screen, the frequency of reported injuries. There was some question as to whether livestock were sometimes reported as being injured and sold at a depressed price when maybe that was not the case. Also, this fourth bullet point, wiring on. I mean, this was a practice of when a farmer or rancher would have their cattle on a train. They stop at a particular town. They're given a price by the stockyard. The producer's not happy with that price, so they figure they'll go to the next town and try to sell the cattle in the next town. Well, the producer or the packer in the town where they stopped would wire on to the potential buyer in the next town and tell the potential buyer what price the rancher was quoted, and then the potential producer in the second town would quote that same exact price. And so then the rancher would need to pay for that transportation. The livestock would have lost weight. This was another example of, or another way in which it was alleged that the companies were engaging in anti-competitive behavior. Okay, so as a result of this, there was an investigation by the Federal Trade Commission that was initiated by President Wilson, and that investigation came with a recommendation that the stockyards and the related facilities should be nationalized. Now, that obviously wasn't a desirable outcome for the Packers, and so there was negotiation that ultimately ended in a consent decree, and then an agreement that or led to the legislation that became the Packers and Stockyards Act. And through this, through the consent decree as well as the Packers and Stockyards Act, the Packers agreed to divest the ownership of the stockyards, or the real estate, the stockyards real estate, railroads, market newspapers. So they were relinquishing some of the control that they had over the infrastructure, And then USDA was going to regulate the unfair and deceptive practices through the Packers and Stockyards Act. This was the statute was challenged, and in Stafford v. Wallace in 1922, the U.S. Supreme Court upheld the challenge to interstate commerce, upheld the application of the Packers and Stockyards Act. Okay, I mentioned earlier it's been amended several times. Brook's going to talk about some of the more recent amendments, but adding it's called the Packers and Stockyards Act, but now it also regulates swine contractors and live poultry dealers. Now, somewhat ironic that the impetus for the Packers and Stockyards Act largely was industry concentration, and as we look at the state of the industry now, it's really as concentrated or perhaps more concentrated than it was 100 years ago. This lists all of the amendments, and again, just to highlight how frequently this statute has been amended. And if you go through this and look at all of the dates, it has never gone 10 years. It has been, I think this is 25 amendments, so it's 100 years old. It's been amended 25 times, so an average of every 4 years. And like I said, I don't think it's ever gone 10 years without being amended. Okay, so the overall purpose: ensure fair competition and fair trade practices. It is protecting the financial interests of the producers, of the farmers and ranchers, but also protecting everyone, the producers as well as consumers, from monopolistic behaviors. Okay, so first, when you look at the Packers and Stockyards Act, I think the first thing you want to look at is, if you're looking to apply it, is there a regulated entity, or who are the regulated entities? And there are 4 different types of entities that are regulated. We have the Packers. I guess I say 4 types. That's looking at stockyards, dealers, market agencies, which is kind of a broad range of businesses that are regulated. But it includes the Packers, the stockyards, the swine contractors, and the live poultry dealers. Now, any statute's going to define these terms. Here is the definition of Packer. You can see it's Packer, someone engaged in buying livestock for the purposes of slaughter, other business activities relating to meat as well. Now, the definition, each of those other regulated entities is defined as well. Packer is the most concise definition. The other definitions are it's a little bit more lengthy, but you have to look at what is the business doing, and do they fit within one of these definitions? The business may fit within multiple definitions. So they may be a packer as well as a live poultry dealer, and then they're going to have to comply with any of the requirements that are on either of those entities. Okay, really the heart of the Packers and Stockyards Act are the unfair trade practices. Now, for the section 202 is the unfair practices for packers, and you can see swine contractors are included there, as well as live poultry dealers. There is another prohibited trade practices section, I think it's 307 or 309, that is for the stockyards, and and the other entities that are kind of encompassed with the stockyards. But when we look at these unfair trade practices, I just have some bullet points kind of providing an overview for some of these trade practices, but they can't engage in unfair, unjustly discriminatory, or deceptive practices. You can't give unreasonable preferences to one producer as opposed to another producer. You can't apportion the supply to restrain trade, manipulate prices, apportioning territory, having an unreasonable or discriminatory charges. So all those are the specifically listed prohibited trade practices. A couple of other provisions that are very, very important. I said prohibited trade practices are really at the heart of it, but this prompt payment requirement, this may be the provision that is most frequently utilized or violated, because this requires that anyone that's purchasing livestock has to promptly pay for the livestock. Okay, seems like a fairly straightforward point. I think the important thing is if that payment is not made, that that packer or other regulated entity now has violated the Packers and Stockyards Act. They're subject to sanctions. They that can have an impact on their ability to continue to do business. And so this prompt payment requirement really gives USDA the ability to have control over who is no longer able to engage in this business. So that becomes a very important requirement. And when you have a business that is not able to make its payments, often that snowballs and it becomes more and more of farmers are not going to be paid. So this requirement, if it's violated and then enforced quickly, it can really limit the damage that's done by a regulated entity that's having financial problems. The second provision that is very important, there is a statutory trust, and you can see there's 3 different sections in the act that relate to the statutory trust, but this provides a way for that seller who isn't paid a way to get some priority if there is a bankruptcy or if there is competition for the assets that the regulated entity has. Okay, so I think these are really 2 very important provisions that you need to be aware of if you are dealing with a client that's involved in the livestock industry. Okay, for the administration of the Packers and Stockyards Act, it's administered by USDA's Ag Marketing Service, the Packers and Stockyards Division. I'm forgetting now what year the reorganization was, but it really was just a few years ago. It was administered by USDA's Grain Inspection Packers and Stockyards Administration, or so-called GIPSA, but now it's through this Packers and Stockyards Division of USDA's Ag Marketing Service. There also is a private right of action that's available. The USDA's website has a lot of resources. I would direct you, if you have a client, if this is an issue for you, I would direct you to USDA's website. I have some of their next couple slides. I have screenshots of some of the website, but they have a lot of resources. They have ways in which you can file a complaint. This is just kind of listing the types of enforcement actions that USDA takes, giving notice of violations, the stipulation agreements. They can pursue, formal legal process and take a court action in the U.S. District Court for violations. They also have a listing of suspended businesses. So I mentioned that, the failure to promptly pay is the most frequent reason for a suspension, but they have a list of all those entities that are suspended. And just looking at the last line here, accordingly, when you do business with suspended businesses and individuals, you do so at your own risk. So again, if you're representing clients in the livestock industry, this is probably something you want to be familiar with. And here we have a list of the recent administrative actions that USDA has taken. Okay, I want to just talk real quickly about the Pickett versus Tyson case. This is, I guess 2005, so 17 years ago. This is a case that provides an example of the circumstances that can give rise to a complaint under the Packers and Stockyards Act. Pickett, Pickett, it was a class action. There were a number of plaintiffs that filed suit against IBP, which was then acquired by Tyson. And when you look at the the product procurement here, or the ways in which IBP could get cattle for their plants, And they had really three different options. They could go to the spot market and purchase cattle. They also could enter into market agreements with feedlots, and that would have arranged for to take title when Tyson, or when those cattle were ready to go to market. Then you didn't have to arrange for the purchase at that time. You had the terms provided by this market agreement, and the price for those market agreements was usually based on the spot market. So even though the spot market was not where the cattle were being produced, the price was determined by the spot market price. And then the third way that IBP could get cattle for their plants was to just raise them themselves, and they did that. So when IBP needed cattle for their plants, they would use one of these three methods. They would either put their own cattle, they would have marketing agreements that they would have the cattle delivered, or they would go out and purchase them. And the issue in this case was really whether the choice that IBP made in using one of these three options, whether that choice was depressing the spot market. Okay, now obviously you can look at it and say, well, they had an interest in depressing the spot market, because then if they purchase on the spot market, they're going to pay less, and also if they use the marketing agreements, they're going to pay less. Okay, so suit was filed by farmers who sold through the spot market, not farmers that sold through marketing agreements, just those that sold through the spot market. So again, the allegation is that Tyson or IBP was manipulating the way in which they purchased so that they could reduce that spot market price. Okay, so this case went to trial, and the jury awarded a verdict of $1.2 billion. Big verdict, got a lot of attention. Post-trial motions, the judge reduced that verdict. So, or the judge ruled on the other side. So that verdict was never actually entered, but still got a lot of attention that a jury would come up with that amount. So the way, I guess I'm going to skip through the mechanics of the marketing agreement, but the court, the Court of Appeals, the Circuit Court, they looked at sections 202 of the Packers and Stockyards Act to determine whether their use of the marketing agreements was adversely affecting competition. And ultimately, they concluded that it was not, that what IBP and Tyson was doing was not a violation of the Packers and Stockyards Act. So Pickett, the plaintiffs, they did show that the market price was depressed, but Tyson was able to show that they had a legitimate business justification for making choices to buy through these three options. And the plaintiffs were not able to show that this business justification was just pretext. So the Packers and Stockyards Act was applied. It was not, or the analysis was done, but it was not violated. Okay, before I turn things over to Brook, I just want to mention that this program, we're talking about the Packers and Stockyards Act, but the Perishable Agricultural Commodities Act has some similarity in that it's imposing, PACA is imposing those fair dealing standards upon marketing of fruits and vegetables. So just as if you have a client that's in the livestock industry, you need to be familiar with the Packers and Stockyards Act. If you have a client that's buying or selling fruits and vegetables, you need to be familiar with PACA, and that's something that I think in a future program we'll talk more about that.
I'm going to just talk a little bit about back to a tiny bit of history here, which is in that reorganization that Ross talked about, and this will help you understand what sort of why the word GIPSA is still used, even though it's technically the GIPSA division doesn't administer the Packers and Stockyards Act anymore, which was, okay, in 1994, there was a reorganization that created the thing called GIPSA. So going way back to the origin of the act, it was called the Packers and Stockyards Administration. And that's kind of where this PSA abbreviation first came from. And you'll notice I always use P with an ampersand and S for Packers and Stockyards because I'm more new to it. So the GIPSA was the entity that was with an internal division within USDA from 1994 until this most recent shuffling, so to speak, which was, I think, in the late 2000s. I think that's right, somewhere in there. And so then GIPSA was technically no longer the entity that administers things, but yet everyone still uses that term. And the word GIPSA regulations still is with us today, even though technically GIPSA is not an actual division within USDA any longer. So when you hear the word GIPSA, just understand that it has this little historical significance, and people still use the word GIPSA regulations to mean the regulations that are under the Packers and Stockyards Act and the GIPSA rule, because we have this anomaly in federal law where, for whatever reason, people use these words rule instead of regulation like we use in state government. And so the GIPSA rule just means the regulations that administer the Packers and Stockyards Act, which are no longer administered by anything called GIPSA. So that just gets you a little bit of background so you can understand where that term comes from. And like Ross had up, I wanted to repeat these amendments because it is quite a prolifically amended statute. And we're going to talk about a couple of these because there are just a couple of them in around the 2000 era, and then 2008, there were big ones. And but you can see all these things going on. Every time there's a change, there's something going on. Might be little, might be big, you never know. And these are not actual all, or I'll put it this way, these are not actually all amendments of the Packers and Stockyards Act. Many times it was amended by the Farm Bill, or it was amended by an Appropriations Act as one of those little tack-ons at the end of an Appropriations Act, something that, amended. So there's just so many ways that this entire sort of bailiwick of livestock market regulation gets tweaked, and it can be a nightmare to sort of keep track of. But the big themes, again, as Ross talked about, the prompt payment and all of those prohibited trade practices, including some which were pretty vaguely worded, and some of these amendments have to do with that. Okay, now I'm going to talk about what is really the recent things, and here's some of them, which were all forms of expanding the Packers and Stockyards Act authority to do new things in the market that, because of, and it's mostly all because of the rise of production contracts and the shrinkage, so to speak, of the amount of actual market sales that are actually going on. And, so with the decline of, freely publicly sold livestock and the increase in production contracts, they just had to keep rolling with the punches, as Ross alluded to. So in 1987, it wasn't until 1987 that poultry even entered the picture in the Packers and Stockyards Act. So, it started with beef. Beef was the focus. And it wasn't swine or poultry for decades and decades and decades. And you can see how an act that was written all just to deal with beef, and just to deal with beef when there were open markets and market sales, and there was a spot market as the primary way of producers selling. Now the world is just completely different, particularly in swine and poultry. So 87, it was expanded to poultry. Very few differences in the way that it's administered. Most of all the same provisions apply to poultry as apply to beef. Okay, 2002 is when swine entered the picture. Now, there are big differences here. They did not get the benefits that when poultry was folded into the sort of the tent there that is being regulated. That was pretty much a wholesale adoption of, okay, poultry producers and poultry transactions are going to get all the same things. Swine didn't get that. They did not get a bonding requirement for dealers and anybody essentially, and we'll get to a way to understand that, but everybody who's required to have a bond is just about anybody who could go belly up while they're holding your money, so to speak. And when I say your, I mean a producer's money. So no bonding requirements with regard to swine. Never happened, still doesn't exist today. No prompt payment requirements with regard to swine. That's a big one. And no statutory trust provisions, which is this idea that there's a statutory trust on that money if you haven't been paid, but yet somebody else is holding your interest or your percentage of the sale price, and the animal is already out of your possession. This statutory trust is created. They don't have that in swine. And also, or I should say, so primarily what they got was the prohibited trade practices applicable to swine. And again, some of those are pretty vaguely worded. And if you go back to Ross's slide, maybe we'll do that a little bit later if we have time, you see that many of those prohibited trade practices, just so you get a little finer understanding of how problematic it is to enforce this law, many of those prohibited trade practices have their own legal understandings and or definitions that come from other laws, like the Sherman Act or other types of potentially or primarily anti-competitive type statutes. So some of those, you can borrow case law, so to speak, to say what is a certain type of monopolistic practice or this or that. But then there's those really vague ones like an undue preference or an unfair advantage, and some of these ones that are very vague that aren't really like borrowed concepts from antitrust law. They are kind of things that have been made out of I don't want to say whole cloth, but they are things that are somewhat new in this statute and don't have some type of other borrowed definitions that are easy to use and apply to the facts of livestock sales. That's why it gets so fact specific, and it's very frustrating because producers are always told, well, it depends. Is this going to be a violation of one of those prohibited trade practices? Well, we have to look at all the facts, and and that can get there's not a whole lot of black and white a lot of times. So now, also in 2002. There was the beginnings of what we see much more now, which is the use of confidentiality clauses by buyers, by dealers and packers and anyone else who's purchasing livestock. They were statutorily prohibited from using confidentiality clauses. And it's a little bit of a long explanation to let you know exactly how they were prohibited. But the bottom line is, this was the beginning of sort of the federal government reaching inside these contracts and actually saying, no, you can't use this term. Or if you use this kind of a contract term, it can only say this. And so that began a much more sort of invasive era with Packers and Stockyards. And there's more of that coming. All right. Now, one of the things I want to talk about that wasn't one of the core principles of or objectives or regulatory tools that Ross had mentioned is a really important one. And I wanted to make sure I include this in here so that you understand, particularly as attorneys who might be practicing in rural areas where you might be dealing with your livestock auction in some capacity, or you've got clients that go there, or you have clients who buy there, or you represent the auction itself. Somebody asked the question, by the way, in the Q&A about applying to little auctions, et cetera. It applies to everybody. Now, there are some definitions which we'll show real quickly here, but essentially just assume that if there's an auction, a livestock auction of any kind, live animal market, it's going to be regulated as long as it's selling these species. And so there are GIPSA, or I'll use GIPSA. There are Ag Marketing Service USDA employees who are responsible for regulating these auctions geographically all over the state of Pennsylvania or wherever you may be, and they have jurisdiction over these little auctions all over the place, as long as they're selling poultry, beef, or swine, or lambs. Actually, also lamb came into the picture too. Now, the reason why I'm mentioning this is an important concept. you have this statutory trust concept, but you also have the federal government reaching in and controlling what's going on at that auction or market for the benefit of producers by exercising jurisdiction over their bank accounts. So these bank accounts that are maintained by the auctions for cashing the checks from the buyers and then paying the seller, and on a consignment basis, and obviously every auction or some auctions may have slightly different ways that they deal with that legal relationship of the animal passing through, but it's all basically a consignment, and the auction is taking their little piece, and maybe there were some services provided while the animal was there, and that's got to get paid for out of the sale proceeds, and then the owner of the animal finally gets their cut. Well, in that process where the auction is holding the money, then the federal government is basically got its finger in there too. And has jurisdiction over those accounts. And the cardinal rule with regard to those accounts, and I just know this issue because I've been personally involved in this, and I've seen the audits that they do of a auction's accounts, and I see how burdensome, onerous, I don't know. You're holding somebody else's money. You better be pretty darn careful. This is money being held in trust. And so the cardinal rule of this entire setup is that you must maintain a balance sufficient to pay all the outstanding purchase obligations at any given time. Every snapshot, every second of the day, you have to have enough money in that account to pay every seller of an animal who is owed money because the animal has now passed through the auction. So, and they got to keep those accounts clean. They have to be able to prove that they've maintained those balances. They have, and if they don't, if there are points in time where their account balances fell below their obligations to the sellers who were selling through that auction, they're in trouble. And the penalties are not insignificant. So just understand that the auction operators are answerable very specifically to the federal government and the field agents who are out in the field with jurisdiction over them. Now, how often audits happen is another question. And, I do think it is sort of complaint-based, but it is not taken lightly. Let's just put it that way. And I've been personally involved in these things, and it can get really messy, particularly if you've ever been to one of these auctions. You know how it is. It's not this is not the most, modern, tightly run ship that you may have ever observed in your life. That's the key thing, is just to understand that anytime the seller has the proceeds that the sale of their animal produced is being held by somebody else and they haven't received it yet, USDA has jurisdiction over that money wherever it's sitting. That's probably a good way to say it. And this idea of the custodial accounts is really important. Okay.
All right, Brooke, I just want to remind you, you have about 5 minutes left for you.
Okay. All right. This will be I'm certainly going to need more, but we will just talk about that. Okay. So now in 2008, there were a bunch of amendments through the Farm Bill to the Packers and Stockyards Act. It added a right of cancellation for poultry and, I should say, swine production contracts, not swing, minimum of 3 days. You can't go below 3-day right of cancellation. You can make it longer if you're, a packer who is getting animals produced for them by contract. There is this whole thing about a additional capital investment disclosure statement, which means if you sign up and you sign a production agreement, they have to have a disclosure statement that is very specifically spelling out to you what all you're going to have to do to comply with their production requirements and how much it's going to cost, or estimates of how much it's going to cost anyway. It's one of these, full disclosure type of, producer protection measures. There is controls over venue and you can't say, oh, well, everything, any dispute under this contract is going to have to be decided in Oklahoma or something, and you're here in Pennsylvania. Wherever the principal part of the performance of the production contract takes place, then that is the venue for the settling of any legal disputes. And also the choice of law provisions, they have to be specified, and they can, if the home state where you are, where the principal part of performance took place, requires something specific, then it has to be that. So in other words, if Kansas wanted to say every animal production contract in Kansas, the choice of law provision must be Kansas law, that's going to be good and that's enforceable. That is what essentially the Packers and Stockyards Act now says, that individual states can exercise that kind of control. And so they're interfering, they're altering, private contract rights here. Arbitration requirements can be completely declined. Producers who are producing animals for someone else under contract can always decline arbitration, and their right to go to court is preserved 100% at their option. That's ironclad in Packers and Stockyards now. There was a provision about USDA in 2008 promulgating regulations that did a bunch of things. And Audrey, I'm going to talk a little past here because I just got to. They were to promulgate regs that were going to define this vague term of undue and unreasonable preference. They were also going to promulgate regs that dealt with what's a reasonable notice of suspension. And what that means is you've produced your birds, your broilers, and then the owner generally is anticipated, the animal owner, to now put another flock in there. Well, if they're going to suspend the automatic refilling of your production facility with broilers, for example, they have to give you a notice of suspension. And these were regs that were going to spell out, some pretty stringent requirements for those states, because that's cutting off your lifeblood. If you don't get your house filled back up with chickens after they moved out the last flock of chickens, your income's done. And you might have millions of dollars worth of debt for this chicken house that you built specifically for Purdue. And now what? They're unilaterally going to decide not to put broilers in there? That's the kind of thing they're trying to address here. Also, there was requirements or the regs were to address requirements about some of these additional capital investments. What was going to be reasonable to require somebody to do to perhaps customize their existing chicken house for Purdue's birds and Purdue's production requirements if they're going to be signing with Purdue. And also reasonableness during the term of the contract. In other words, if Purdue's rolling out a whole new animal health program where the birds are to be, whatever it might be, and something has to be done that's going to cost you money in changing your layout of your birdhouse, there was some controls that were to be exercised over what was a reasonable amount of capital investment that you could ask from somebody once they've already signed the contract. And then all of a sudden you're going to impose all kinds of new terms. They spent $5 million to build the chicken house, and 2 years into it, you're asking them to put another $3.5 million because of new production requirements, that sort of thing. So this all became what's called the infamous, I call it infamous, the infamous GIPSA rule of around 2010 or so, 2010. And we'll get to that in a minute. You want to see a really nice resource? There's a great CRS report here that summarizes this whole thing. But what ended up happening was this GIPSA rule just blew up. And in 2008 was the farm bill that instituted this. And it's called the GIPSA rule. And there was all this controversy for years over it. But it was just one attempt to amend the existing Packers and Stockyards regulations. Okay, so the terminology can get confused. So finally, after published as proposed and public comment period, and it was a lot of furor and fire and brimstone, there was a final set of regulations that were in fact promulgated in December of 2011, and they became effective in February of 2012. Well, since that time, they have been so monkeyed with and so altered, first of all, and primarily by every time Congress didn't like something in them, there would be the next Appropriations Act that would come down the pike in 2013 or 2014 or whatever. They would tack on things that said, well, you can't spend any of your appropriated funds, USDA, for the enforcement of this section of the GIPSA rule or this section of the GIPSA rule. So they were basically pulling the rug out from under USDA and saying, well, you promulgated these regs, but we're just going to tell you can't spend any federal money to enforce them. So it's like we repealed them. So Congress was doing this constantly to the GIPSA rule through the period from 2012 through 2015. The last tweak that was done by an appropriations bill that altered the regulations was in 2015, I believe. Now,
All right,
I'll skip over it. Yep.
Brooke, I'm going to have to stop you there because we've got a couple of questions and we want to try to get to them.
Okay, okay, hang on a second. Let me just move ahead. And so that's the GIPSA rule. You hear that. Now, mandatory livestock reporting, that's a whole process whereby market data as to what's being purchased for what price is now mandatorily to be required, mandatorily to be reported by dealers and packers. And that is revolutionary. And that is where all of the attention is now with regard to expanding that, because there's mandatory livestock reporting, particularly with regard to swine contracts. There's an entire swine contract library system now, but that does not apply to beef. So the big issue now, and Senator Grassley is, the one who's pushing for it hard, is to have a contract library for beef where there's essentially full disclosure of the terms of beef purchases across the country by all packers. So anyway, I do see the questions. One of them was one that I was going to go ahead and answer. We have one, right? The one on the Animal Welfare Act, the question is, does the Animal Welfare Act have an exception for livestock? Animal Welfare Act is a statute that controls zoos and petting zoos and circuses and all sorts of other things, not production animals. So I do believe that the production of food animals is absolutely exempt from the Animal Welfare Act. Animal Health Protection Act, I do believe that is the general statute on the federal level. I'm more of a state law guy, but I think that is the generally applicable statute on the federal level that does have provisions applicable to livestock. All
right. Thank you, Brooke. I know we've got a couple other questions and Ross is prepared to answer them. We have a question from, I think it's Mr. Robert Brandon, and he asked, does the Packers and Stockyards Act have a registration option like PACA, the Perishable Ag Commodities Act, such as to allow invoice language to supersede the 15-day receivables limitation?
Yeah, so the prompt payment requirement in the Packers and Stockyards, and it states that the payment has to be made the following day after the sale. So it's a very prompt payment. It can be waived. So, important, I think, why would you want to waive that? But it can be waived. Yeah.
Is that all you? Okay.
Yeah, there was another question I saw asking about regulation of small.
Yeah, and I answered.
Correct.
I tried to
you answered that. Okay, great.
Yeah, there is in the portion of my PowerPoint, which I have lots of links in there you might want to get, about the livestock mandatory reporting. I do have a definition of who's required to report, which is very similar. I think it is the same definition of who is regulated otherwise by the other provisions in the Packers and Stockyards Act. That there was a size, how many animals you have to move through.
All right, and then we've got a quickie question that either one of you can jump in. Does poultry also include eggs?
No. The statute, generally it's talking about poultry for slaughter. So, there might be some, I guess I wouldn't want to say a blanket.
Right.
But generally, no.
Right, I agree. This is about the animal sale. Eggs are a completely separate thing. And that's food.
All right. And then we had two questions while Ross was speaking that he actually answered, but we're going to just touch on those real quick. So the first was the Packers and Stockyards Act a model in some respects for PACA or the Perishable Ag Commodities Act? And it was. And then it says, Packers and Stockyards Act is enforceable by USDA and administrative proceedings, is it also privately enforceable? Ross, do you want to speak on either
Yeah,
of
and
those?
the answer is
The
yes,
answer
it
to that.
is. I mean, it can be a private cause of action, as the Tyson v. or the Pickett v. Tyson case is an example of that.
All
And
right.
if,
Oh, go ahead.
and just to note again, you grab the PowerPoint, there's all kinds of good links if you want to understand this more. The big push now, we're all going to see it. If you follow the ag press, you're going to see it. This coming farm bill, and Senator Grassley is the champion of this. They have been pushing so hard because it's all part of the White House's initiatives with regard to anti-competitive behavior, because there's so much suspicion in the beef industry now about pricing being out of whack, and that the beef industry is essentially shortchanging producers yet charging consumers, and the wholesale price of beef is high, but the producers aren't seeing any of that. And so the bottom line is price discovery and market reporting down to literally swine purchasers like Tyson or whoever it may be, JBS. They have to send copies of their purchase agreements, to USDA, actual copies. Now they're kept confidential, but that is quite a move, in terms of talk about government regulation of a market. I venture to say there are very few other marketplaces that have that kind of government involvement, perhaps medical care in some areas, but this is, quite a unique market that the government is literally requiring swine purchasers to send their purchase contracts to the government. That's quite a thing.
All right. Well, thank you, Brook and Ross, for all of your knowledge. So thank you for attending this segment from our Understanding Agricultural Law series, sponsored by Pennsylvania Department of Ag's Ag Law Business Development Center. Materials will be posted on our website as well as on our YouTube channel. And please join us next month for understanding the basics of crop insurance.